Welcome to my video. Today, we're going to discuss some very important aspects of the trademark registration process in India, especially focusing on trademark hearings, show cause hearing status, and the grounds for objections under Section 9 and Section 11 of the Trademark Act. If you've ever applied for a trademark or plan to do so, this video will help you understand how to check hearing dates, what certain statuses mean, and how to respond to objections effectively. So make sure you watch till the end. Question 126. How can an applicant check when their trademark hearing is scheduled, and what are the steps involved in tracking this information? Answer. To know when your trademark hearing is scheduled, you need to follow a few steps. Generally, a hearing for a trademark application may be scheduled if there is an opposition, objection, or dispute that needs to be resolved, or if there is a need for further clarification regarding your application. Here's how you can check when your trademark hearing is scheduled. 1. Check the trademark application status online. Visit the Indian Trademark Office website. You can check the status of your trademark application on the official IP India website. Go to www.ipindia.gov.in. Track your application. Select Trademark under the Online Services section. Then click on Public Search or Check Status. Enter your application number or receipt number to find the status of your application. If a hearing is scheduled for your case, the status will usually show Hearing Scheduled or indicate a date and time for the hearing. 2. Review the examination report or objection. If the trademark examiner has raised any objections, or if there is an opposition to your trademark application, you may receive a communication or examination report from the Trademark Office. This notice may include details about when the hearing is scheduled and any necessary actions you need to take before the hearing. The notice could be sent by email or post. Make sure you keep an eye on the communication from the Trademark Office. 3. Respond to the examination report or opposition. If you've received an objection or an opposition notice, the Trademark Office may schedule a hearing if the issue isn't resolved through correspondence or documentation alone. In such cases, the Trademark Registry will send a hearing notice to the applicant and the opposing party. The notice will specify the date, time, and place of the hearing. If you don't receive a response or hearing notice, and the status shows an objection or opposition, it's a good idea to respond promptly to avoid unnecessary delays. 4. Check with the Trademark Office, manual follow-up. If you are unsure of the hearing date or need more specific information, you can also contact the Trademark Office directly. You can either call the Trademark Office where your application was filed, visit the Trademark Office in person. This may not be convenient or necessary if the application is being processed online. Email the Trademark Office for updates on the status or hearing details. 5. Use a trademark attorney or agent. If you have hired a trademark attorney or agent, they will typically handle all communications, including the scheduling of hearings. They will ensure you are notified of any hearing dates and can assist with preparing for the hearing and responding to any issues that arise. 6. Monitoring the journal for updates. In some cases, if your application has been contested, or if a decision is pending based on the outcome of a hearing, you may see updates in the Trademark Journal. You should monitor the Trademark Journal as well, as the publication may contain notices about hearings or final decisions related to your application. Question 127. What does the status, ready for show cause hearing, mean in the trademark application process? And under what circumstances is it typically assigned? Answer. The status, ready for show cause hearing, in the context of a trademark application, indicates that the Trademark Office has reviewed your application and is now proceeding to schedule a show cause hearing. This usually happens after an objection or opposition has been raised against your trademark application, and the office is seeking clarification or a formal response from you regarding the issues at hand. A show cause hearing is scheduled when 1. Objections from the examiner. The trademark examiner has raised objections about your trademark, such as distinctiveness, similarity to other marks, or non-compliance with the requirements of the Trademark Act. 2. Opposition. There may have been an opposition filed against your trademark by a third party during the publication in the Trademark Journal. This could be due to claims that your mark is too similar to theirs or infringes on their rights. 3. Failure to respond or resolve issues. If you did not satisfactorily respond to the objections, or if the issues remain unresolved, the office may schedule a show cause hearing for you to present your arguments or clarifications. For more detailed information, visit the official website of VMK Professionals, www.vmpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Question 128. What are the grounds of objection under Section 9 for the refusal of trademark registration, and how do they apply to different types of marks? Answer. Grounds of objection under Section 9. Absolute grounds for refusal. Section 9 primarily deals with absolute grounds for refusal of registration, which means the refusal is based on the inherent characteristics of the trademark, rather than its similarity to an existing mark. Never 1. Non-distinctiveness. Section 9(1). A trademark will be refused registration if it is not capable of distinguishing the goods or services of one person from those of others. In other words, a trademark must have distinctiveness to be eligible for registration. Trademarks that are too common, generic, or descriptive of the goods or services they represent are not considered distinctive. Example, a mark like Best Coffee for coffee products would be refused because it is descriptive of the quality of the product. 2. Descriptive or generic marks, Section 9(1)(b). Marks that are merely descriptive of the quality, quantity, intended purpose, value, geographical origin, or other characteristics of the goods or services are not eligible for registration. Example, sweet for sweeteners or fast food for restaurants. Generic terms that have become common names for the goods or services in the market will also be refused. Example, computer as a mark for a computer manufacturing company. 3. Marks lacking distinctive character, Section 9(1)(c). If the mark consists of common shapes or designs that are customarily used in the trade or are needed to identify the nature of the goods services, they may be rejected. For instance, a simple geometric design or a shape that is not distinctive enough for the particular goods services cannot be registered. Example, a simple circular shape for a watch or a rectangular box design for packaging. 4. Marks consisting of deceptive or misleading features, Section 9(2). A trademark that is deceptive or misleading with respect to the goods or services it is intended to represent cannot be registered. Example, a mark that gives the impression of being of a particular quality, origin, or nature, but is not, could be misleading and is therefore not registrable. Example, genuine leather for goods that are made of synthetic materials. Marks consisting of commonly used symbols, Section 9(3). Trademarks that are made up of common symbols, motifs, or signs that are used widely in trade and do not have inherent distinctive character will be rejected. Example, a mark consisting solely of a common star symbol or heart shape for a wide range of goods. 6. Marks contradicting public policy or morality, Section 9(4). A trademark will be refused registration if its use would be contrary to public policy or morality. This provision prevents the registration of trademarks that may be offensive, discriminatory, or socially unacceptable. Example, a trademark with offensive language, hate symbols, or those promoting violence or discrimination. Question 129. How can an applicant overcome objections raised under Section 9 of the Trademark Act during the trademark registration process? Answer. Steps to overcome objections under Section 9. 1. Respond to the objection in writing. When the examination report is issued, you will need to file a response within the specified time, usually 30 days. In your response, address each objection raised by the examiner, providing arguments, evidence, and legal precedents to counter the objection. 2. Submit supporting evidence. If you are claiming secondary meaning, provide evidence of use in the marketplace, e.g., advertisements, sales records, media coverage, to show that your mark has become distinctive over time. If the mark is descriptive but has acquired distinctiveness, provide evidence demonstrating public recognition of the mark. 3. Amend the trademark, if applicable. If the examiner's objection is based on something amendable, such as slight modification in the wording or the addition of a logo, you may amend the mark and submit the updated version. 4. Request a hearing if needed. If the examiner still refuses to accept your response, or if there are complex objections that need more detailed discussion, you can request a show cause hearing. This hearing will allow you to present your arguments in person. 5. Seek legal help. If you are unsure of how to address the objections or need assistance preparing your response, it is advisable to consult with a trademark attorney. They can help you craft a solid response to overcome the objections raised under Section 9. Question 130. How can an applicant address objections raised under Section 11 of the Trademark Act regarding similarity to existing registered trademarks or other grounds for refusal? Answer. Grounds for objection under Section 11. 1. Similarity with existing registered trademark. Section 11(1). A trademark shall not be registered if it is identical or deceptively similar to an existing registered trademark. This includes cases where the marks are so similar that their use would likely cause confusion or deception among consumers. It also applies if the marks are identical or confusingly similar in terms of sound, appearance, or meaning. 2. Similarity with well-known trademarks. Section 11(2). Even if the trademark is not identical to an existing one, it cannot be registered if it is similar to a well-known trademark. This includes situations where the use of the mark would take unfair advantage or dilute the distinctiveness of a well-known trademark. Well-known trademarks are those that have a high degree of recognition across a wide geographical area. 3. Marks identical or similar to a mark with prior use in India. Section 11(3). A trademark shall not be registered if it is identical or similar to a prior used mark that is known in India, even if the prior mark is not registered. If a trademark has been in use for some time and has established a reputation, any identical or similar mark may cause confusion or harm the goodwill of the earlier mark. 4. Descriptive marks. Section 11(4). A trademark that is descriptive of the goods or services it represents may be rejected. For example, a mark that directly describes the nature, quality, or geographical origin of the goods services may be considered generic and not distinctive enough to be registered. Examples of descriptive marks include terms like fresh for fruit juices or fast for delivery services. 5. Marks containing names of public interest. Section 11(5). Marks that include generic names, common surnames, or descriptive terms that are used by the public for trade are not eligible for registration. Marks that consist of or resemble a government emblem, national flag, or any symbol that is of public interest cannot be registered. For instance, you cannot register a trademark that includes the image of the Indian flag. 6. Marks contrary to public policy or morality. Section 11(6). A trademark will be refused if its use is contrary to public policy or morality. For example, marks that include offensive, immoral, or inappropriate content, such as those related to hate speech or discriminatory symbols, would be refused registration. 7. Conflict with official signs or symbols. Section 11(7). Trademarks that include official signs or symbols, such as the Red Cross or symbols of international organizations like the UN, or those that are likely to mislead consumers regarding their association with government or international organizations, will be refused registration. If you want to register your brand name, logo, or tagline and legally secure your identity, don't wait. Get expert help with the entire trademark registration process. Contact VMK Professionals, your trusted legal and business partner, to ensure your brand is protected under the law. Visit www.vmkpros.com and get started today. And that's it for this video. We hope you learned something new about trademark registration and how to handle objections and hearing notices. If you've ever faced a similar issue or have a question we didn't cover, do let us know in the comments. We'd love to hear about your experience. Don't forget to like the video, subscribe to our channel, and hit the bell icon so you never miss an important update related to legal and business compliance. See you in the next one. Thank you.